Welcome at the second stage of the selection to the High Qualification Commission of Judges, Roman. Good afternoon. The Selection Commission is conducting this interview in its full composition, and these are Robert Brugheisen, Ivan Mishchenko, Serhiy Verlanov, Tadza Zhachny, and Stephen Markman. Judge Evhen Mezentsev has announced self-recusal. As far as I understand, this is related to the fact that you are both members of the Voluntary Territorial Defense Unit, Mria, the Dream. I hope, Roman, that you're already familiar with the procedure of our interviews, but nevertheless, let me tell you that if for any reasons our interview is interrupted, we will definitely reschedule it for another day, some other time, and we will continue it starting with the place where it was interrupted, in case this happens. The members of the Commission will ask you questions and will take turns in this process. You will have a chance to answer the questions. Please give concise answers to the core of the matter, because there are a lot of questions and there is not that much time allocated. And the member of the Commission can limit the time of your answer if he has already got the answer to his question. Before the interview, you will have a chance to present yourself, to tell about your ideas, your motivation, and to tell why exactly you decided to apply for the new HQCJ. And finally, let me tell you that the rapporteurs at your interview are my colleagues Robert Brugheisen and Serhiy Verlanov. With this, let me give the floor to them, and let's start our interview. Robert?
Well, good afternoon. Yes. Please go ahead with your introduction, if you can, and please explain who you are and what your motivation is to participate in this competition.
Good afternoon, dear Mr. Chairman, dear Commissioners. I'm an associate professor of the Department of Civil Law of Kyiv, Shevchenko National University, and I'm a practicing lawyer. I am teaching a number of disciplines at the university. One of them is a general one for all the students, and I also have special courses for master studies students on corporate law and the course on civil practices of the European Court of Human Rights. And besides that, students have asked me to sometimes get engaged in their court debate. I also used to be a researcher in two interdisciplinary international projects, EU-funded projects. I was engaged in the preparation of several legislative acts, like the law of Ukraine on electronic fiduciary services, on limited liability companies, and the law of Ukraine on joint stock companies. And it should be indicated that different stakeholders engaged me. Sometimes that was a high commercial court, like when we worked with the law on limited liability companies, or the Ministry of Justice when it concerns the law on electronic fiduciary services. As a practicing lawyer, I started my activity in 2005, and since that period of time, I've been counseling different clients and representing different people in courts of different jurisdictions. I've participated in many court trials. I've seen a lot of judges, and I came across both the people who sometimes ignored any ethical norms and rules of procedure, but also I've had a chance to meet the exemplary judges who showed high level of competence, ethical standards, and were the best samples to follow in the administration of justice. Now we have a unique opportunity to update the judiciary to leave the best people in the profession. And now I talk about qualification assessment for about more than 2,000 judges, and we need to fill the vacancies with the candidates. We have 1,800 vacancies, but I would say that this is not the real figure. It will have to be studied how many judges we need. But the people to be selected should be the judges who, in terms of their competence, expertise, and skills, will be the embodiment of justice. And a reservation should be made here that the results of the HQCJ's activity will not come right away, will not appear right away. The capacity of the judges to serve their goal depends on the perception of both the judges and their selection process. I'm convinced that a healthy judiciary cannot exist for a long period of time if it is not supported by the society and it's not perceived well by the society. And let me express an unpopulistic idea that the Commission should keep away from the temptation to fill all the vacancies right away, because its main task is not just to show the willingness to introduce changes into the selection, but really to introduce these changes. And the changes should be at least not resisted by the society, and the very Commission itself should introduce the best practices that were suggested by the Judicial Appointment Commission in the United Kingdom, or the ones that were suggested in the Missouri Plan and other cases. They are all based on the merit-based instruction system, if I'm not mistaken, and the theory of positive selection of judges. So to improve the selection procedure and to improve the procedure of qualification assessment, this experience must be perceived and borrowed. And as far as I understand, the experience of your Commission shows that you also use this merit-based instructions procedure. And there should be short-term, middle-term, and long-term tasks for the Commission. There must be some changes that refer to some documents only, but there are also changes related to the amendments in the law on the judiciary, in particular as far as the selection exam is concerned. Because if you'll give me a chance later, I will provide some further explanations on that. That's all from me.
Thank you for your introduction. May I ask you, in your motivation letter, you say that there are many cases that you have experienced where domestic court decisions demonstrate an exemplary level of reasoning. But there are also cases where judges are negligent of their duties, do not meet the requirements of a judge in terms of professional competence and ethical conduct, and that their actions cause irreparable damage to the authority of the judiciary. It's an English translation of your letter, but you will recognize the sentences. And what you say, and then, is that you believe that to prevent this, judges should be selected which will not cause doubts in the future. And by selecting the good judges, it will increase trust in the courts by itself. And then you say, therefore, we, or the HQCJ, should be selecting people who are role models for others. My question to you is, if you want to select role models for others, that can only be done by role models, because otherwise it gets very difficult. So can you please explain why you are the role model, competent and able to select role models for the judiciary?
Well, in my motivation letter, I was not only writing about role models and samples to follow. I meant the competences of judges. We need to realize whether the person is capable of administering justice in general, whether the person is skillful enough, whether the person can have critical perception of the information, communicate and work in a team, and effectively manage work processes. And this can be assessed via testing. Whether I consider myself to be a role model and a sample to follow, an exemplary person, well, I think that at least some competences that are necessary for selection are something I do have, but I cannot call myself a role model. It's not me to assess this, of course.
Okay. Well, thank you for the question. We have decided that this round we would do it a bit different than in other interviews. And the idea is that I now pass the floor to my colleague, Judge Verlanov, and then the others will ask questions. And if there are any subjects left, it will come back to me. And then we hope to do this more efficient within the time that we have available for the interview. So I'll please pass the floor to Mr. Verlanov.
Thank you, Robert. Good afternoon, Mr. Roman, to continue with Robert's questions, let me clarify about the testing. In your motivation letter, you indicate that it's necessary to change the methodology for assessment of candidates and incumbent judges. And you also refer to the fact that the tests that were used for assessment are outdated and obsolete, and they require some improvements. What is the main drawback of those tests, and where would you like to improve them? Thank you for the question. While getting ready for this interview and while generally getting ready for for writing my motivation letter, I actually referred to the Judicial Commission that is selecting judges in the UK, and their testing is a little bit different. I mean, besides law testing and psychological testing, they also have a special characteristics of situational cases. When you have a case that may possibly appear in court, and there they test not the knowledge of the law, but the ability to apply this law, the way the judge will determine the consequences of a certain course of actions, and not just knowledge and procedures. Also, there are some questions for critical thinking. For example, the candidate has a test for 11 pages, and then questions are asked. So they assess not just the knowledge of the law, but the competences. And as far as the phrase my motivation letter contains is concerned, it refers to the loyalty test, psychological test that was introduced by the previous HQCJ. I think that the Commission did not provide proper explanations as to what it meant by those loyalty tests and what were the competences it was meant to assess and why these characteristics need to be tested. What the Qualification Commission wanted to check, whether a person can be loyal in what cases. And this caused a lot of questions to the testing of moral and ethical qualities. As far as the tests related to the knowledge of the law, and this was acknowledged by the Commission, they sometimes does not correspond to the current norms, to the applicable law. There were some mistakes in the test, but the Commission responded in the right way to that. But anyway, that was something it allowed to happen. And also the tests were not always built in the right way, as I think. I saw a question concerning the number of votes necessary for the referendum, but the test actually asked not only about the number of votes necessary, but in how many regions this number of votes should be collected. So I gave the right answer to the question, but anyway, I had to recall to spend too much time. I mean, that there was the wrong structuring of the questions. There were problems about what was checked. There was the problem that there were no situational cases when you analyze critical thinking, and there were no explanations concerning the moral and psychological testing. Thank you, Roman, for your explanations. Here is my next question, again related to changes in the methodology of assessment. So again, in your motivation letter, you indicate that the procedure for the interviews should be changed, in particular through the inclusion of the block of questions on law. Could you please explain to us, do we need testing of the general knowledge of the law if you suggest including this block of questions into the interview? Well, I didn't actually mean that you will have a thorough block on the laws during the interview when you are asked what norm regulates this or that type of relationship, of legal relationship. I just meant that in the context of discussion of the situational case, the candidate had to settle, in particular if he suggests some unconventional approaches, because a part of the qualification assessment presupposes a situational task and a compilation of the decision of the court. Maybe some questions need to be further on discussed, because the candidate during the interview can explain why he passed this decision, what he was guided by, and what was the foundation for his decision. So I mean that you're not going to check the knowledge of the law during the interview, but some clarifications about the way of thinking of the candidate could be actually provided during the interview. Okay, thank you. It's clear. Here is my next question. What is your work experience that shows that you, if appointed a member of the HQCJ, are really capable of working in a team And you can select judicial candidates, and what characteristics, your personal traits of character, show that you are capable of working in a team and make selection. Well, first of all, concerning knowledge checking and testing, though I don't think that this is not the only thing necessary, and I have already mentioned that the procedure needs to be changed. Since 2007, while working at the university, I have to deal with assessment of students on a professional knowledge. This is assessment of knowledge. As far as my professional experience of a practicing lawyer gives me the idea of what a person is guided is by when answering some questions during the interview, whether it's just knowledge or it's pure guessing. Because sometimes during the interview, it's not that important to understand the norm of the law, but it's more important to understand this norm. And in the oral part of the interview, you can actually see the way the person thinks. These skills are developed when you work at the university. They cannot be developed overnight. And the ability to process information, to work with a lot of information, is related to my academic activity, scientific activity. Because we will first of all have to process a lot of information in the HQCJ. And being a practicing lawyer will help me outline the core issues and the core characteristics that are important to assess the candidate's integrity in particular. Clear? Here is one practical question. Taking into account your professional activity of the lawyer, could you please tell me, you have participated a number of times in the court proceedings as a representative of a client in civil cases or a defendant in criminal cases, defendant's lawyer in criminal cases. You are the associate professor of civil law, so most probably you are mainly practicing in civil law, right? It's corporate law and bankruptcy. That's what I mainly deal with. What do you think, taking into account your experience of a practicing lawyer, what are the main challenges that we can see in the judiciary? And if you could give an example that need to be improved. I will be a little bit trivial, so to say, because a lot of colleagues have been talking about the reasoning or unreasoning of decisions, and that's a major problem. But I think that judges often, not often, that's the wrong word. There are some judges who sometimes ignore any ethical standards. When we speak, for example, about some latest cases when the court hearing was adjourned, and in fact I had another court hearing in a different court at that same time, and when asked the court to make the adjournment because of this important reason, because I had to appear to the judge with whom I had an appointment for the court hearing. Well, not the appointment, but pre-agreed. It was pre-agreed. But the judge rejected my motion. She just appointed the court hearing for the time she wanted to have it, and she heard the case in my absence, and she did not satisfy the motion, but then the appeal court, of course, interfered, and the decision was changed. So this is quite a widespread example. Let me specify, Roman, did you provide the evidence of the fact that you had this issue already regulated in a different court proceedings to this judge? It was in the database. You know that the database of court hearings which are appointed for a hearing is in open access. So this information is easily checked, and I gave the number of the case, the surname of the judge, but it didn't work. Okay, thank you. What are other problems that are serious? Well, it's about joint panels. Unfortunately, well, this is not a frequent case, but I've had cases like this. Sometimes, I had a case when a judge of an appellate court was just doing crosswords. during the case consideration. Of course, you always have the judge, speaker, the judge rapporteur. Do you mean the chairman, the presiding judge? No, it was just one member of the joint panel who was doing crosswords. Well, I understand that sometimes these judges don't have enough time to get acquainted with the case materials, but just doing crosswords during the court's hearing is something not quite good. Well, there are a lot of such similar cases. These are all details, but these are ethical issues, unwritten rules of court conduct. And normally, these issues do not reach the High Council of Justice because it's not considered to be a reason valid enough to give a motion, and sometimes they even prohibit giving complaints against the court. I work in Kyiv, where judges are mostly highly competent. Okay, it's clear. Is this a major problem that we have in the judiciary? Or are there more important reasons of challenges? Well, I mean, for example, corruption. Have you ever faced any cases or experienced corruption in your professional activity? I have not, because even if there were any hints, well, you know, I don't play games like this. Maybe there are some colleagues who deal with this kind of mediation, but I just deal with my professional activity. I don't want to deal with such things, so I would be quite rigid in my response, and probably nobody dared talk to me about any things like that. So you have never experienced cases like this? No, and I hope that with my conduct and my behavior, I just give grounds for people not to even start talks like this. Okay, thank you for the answers. And now let me give the floor to Judge Markman. Stephen, you're welcome.
Thank you, Judge. And, Professor Sabodash, thank you for participating in this competition. Let me just ask you a thought question, if I can, please. If you had two selection commissions, each of which were considering 100 of the same candidates, and one of those commissions generally reached consensus on all of the candidates, whether to move them on approvingly in the process or not to do so, and the other one had considerable dissents and differences of opinion on these candidates, which would you say is the more effective commission? What do those two types of commissions say to you about the successfulness of their efforts to identify the best of the best? Or maybe they communicate nothing at all to you, but I'm wondering what you think about those two hypothetical commissions.
Well, if we speak about a conflict in a team, and the commission is a team, so, well, it depends on what came as the reason for lack of consensus. Of course, the commission that reaches consensus will be more effective because they have come to agree on the rules of the game, and they decided to take one path. But when we speak about the team, the commission, which does have consensus, this does not always point to some negative issues. Because there may be some procedural issues which do not prevent the Commission from effective work, but can actually complement this work, because every member of the Commission can make his or her contribution. But I think that the first Commission would be more effective just because they work towards one goal.
Even though they may have the wrong standards. Isn't that the critical thing, that there be some agreement on standards? And
yes, but your question was which of them is going to be more effective. But if you ask me which one I would prefer, so of course I would choose the commission. I would prefer the commission that doesn't have consensus, but at least they have the right standards. There is they have not reached consensus because they don't agree with each other 100%, but they have the right standards. So the quality, the results, the quality of their outcomes will be better. I mean, the quality will be better, but the quantity probably will be better with the first commission. But I would prefer the one without the consensus then, because there may be a quantitative and a qualitative result. So this one is more efficient in terms of quantity, which has consensus, but the quality will be better with the one that doesn't have consensus but has the right standards.
Well, consider the selection commission that you're being interviewed by at this moment. You've no doubt looked at our methodology. I think another way of characterizing the methodology is our efforts to set some reasonable standards for the competition. Are they good standards in your judgment? Are they flawed in some way? Are they insufficient? Could they be more specific, or perhaps they're even too specific as it is right now?
If I've got your principles of work right, so you work on the basis of the merit principle. It's kind of systemic selection on the basis of the characteristics and qualities of the candidate, and this system actually always shows good results. And in parallel, you're also applying the principle of positive selection. That's not only about your selection commission. The Judicial Appointment Commission also has the same principles, and other selection commissions in some states of the U.S. apply this approach when they follow the so-called Missouri plan. If I get you right, the outcomes of such selection show that they are effective. And I don't have any doubts concerning this methodology because I support this process, these standards. And in my introductory speech, I actually mentioned this.
You speak of a merit proposal. I mean, that's a good thing, isn't it? Isn't that what we're looking for? We are looking for, by some standard, the best of the best, are we not? Does a merit selection system always inevitably come down to a comparative system in which we end up perhaps diluting standards over time and comparing candidate A to candidate B and C, and perhaps lose sight of the standards themselves that we've begun the process with in the first place?
Well, I don't think that you tend to omit the standards, even if you compare candidate A to candidate B. As far as I know, you assess not only the knowledge, but the critical thinking of a person. And the selection commission assesses every candidate separately. So it's not just comparative one. It's merit-based. I don't know the internal procedure of the selection commission's work because you have just published the criteria that seem to be important for you. I don't know what the internal process is, but it seems to me that you will assess separately correspondence of each candidate to each of the criteria, and finally you will select the persons who will get the highest scores according to all the criteria. So in that way, you will choose the best of the best out of the people who have reached a certain stage of selection. I don't have any doubts concerning this method because most probably it is the best method out of the ones we currently may have, and it's based not just on the work of the Foreign Commission, Selection Commission, but it also corresponds to the recommendations of the Consultative Council of the Judges. It seems to me that they also suggest this merit-based system for the selection process.
Did I understand or did I misunderstand, Professor, that in your introduction you said something, or maybe even later, said something about not having to propose 32 candidates? Did I misunderstand when you said it wasn't necessary that we propose?
No, I didn't say anything about the number of candidates. I said in my introductory speech that we need to launch the system, take it as the basis. I mean, the system suggested, and on the basis of this, we should make a selection the way the Selection Commission does it.
How would you compare the selection process of this commission with the selection process that we would be looking at with the new High Qualifications Commission? Is there any significantly different approach or different application of standards in the two competitions? Should there be?
Well, the selection commission now doesn't have a chance to have testing. So I know that there was a suggestion like that, but because of the current situation, the commission doesn't have analysis of skills in terms of testing, though we normally have testing if we apply the merit-based principle. So you don't have an opportunity to introduce testing to check the ability of the candidate to identify problems, to analyze information, to understand the law, interpret the law, and to substantiate and reason the decision. So in this respect, the HQCJ should develop its own approaches because the current law does not presuppose their opportunity for analyzing the qualities of the candidate. It presupposes only checking the knowledge of law, general theoretical knowledge of law. It doesn't check the qualifications. But I would say that qualifications are much more important, are also important for the judge. And this is what needs to be changed because the current process cannot allow you to check these skills at this stage. The law allows to do this only during qualification assessment because the qualification exam actually allows the commission to change its procedures and to also check availability of those competences. But this refers only to the qualification assessment, the qualification exam, and only if the commission changes its approach in this issue, because so far it's not testing it quite clearly.
Well, what if I was to say to you that I think we do testing? We're testing you right at this moment. We've tested you by your responses to the same questions that we've given to everyone else. We've tested you by reading the evaluations of people who know you. We've tested you by looking at your background and reading the writings that you've produced as an academician. Isn't that testing? It may not be the kind of testing you're urging, but it's testing.
Well, you know, the ability to assess and process a lot of information to critically analyze it can unfortunately be checked only via some testing. When you give a text to a person and then you give the questions to see whether the person is critically thinking and absorbing this information. What you're doing now is assessing the way I'm prepared, whether I give clear answers to the questions, and the same you checked in the motivation letter. You set the limitation to see whether the person can give concise answers within the motivation letter, within this limit, within those restrictions. That's what you have done. But not all those qualities can be checked through the interview only. For some of those characteristics, you still need some types of testing. That's why, in this respect, I would say that I don't think it's wrong. You work in the conditions you have. But anyway, this remains to be still disclosed in a way.
Let me throw just a few more questions at you because I respect your expertise and you obviously speak with a lot of authority here. But when I hear about testing in Ukraine, and we don't really have testing in the United States for judges very much, if at all, from where I come from. But I hear a lot of talk about psychological testing and IQ testing. I never hear about logical testing, which to me would define one of the most important aspects of a good judge, one who's capable of an intelligent legal analysis, some judge who brings to bear some sophistication in terms of understanding logic. This case is like the last case for this reason, but it's different from the other case for another reason. Why is that never discussed?
On the website of the Judicial Appointment Commission, if you enter this website, and this is the commission which is doing something similar to what you are doing for the HQCJ in the UK, they have pilot testing. They have 10 questions. 10 questions for logical thinking and one of them critical thinking. So these tests are available. I don't remember the exact name, how they are called, but anyway, they just check. You can just check whether you generally can take such tests and pass them. So this methodology is already there, and it is actively used, for example, in the UK.
Let me ask you another question. Can selection by a process of 6 commissioners or 16 commissioners ever be as consistent as testing by one individual, a president, a governor, a head of an oblast or something? Can the kind of process that we're talking about for the High Qualification Commission, this commission, ever be as consistent in that respect? But doesn't collective examinations bring other positive values to bear in the process, having 6 or 16 people?
Well, I think that there should be a commission because it's about plurality of opinions, and every commissioner can really be helpful within the discussion to choose the best option. One person, as experience shows us, no matter how smart this person is, and no matter how many skills, good skills this person has, cannot know everything. That's why in this respect, I would say that the work of such commissions, which is joint work, is much better. It's a better tool because it allows to hear diversity of opinions, even concerning one and the same candidate.
Okay, for better or worse, we have the rules of this commission that we've established, and I think all the commissioners are doing their best to work productively under these standards. You, Roman Sabodash, have been subject to this process. You have some perspective. You've looked at earlier reform efforts. Where are we headed in your judgment? Are we doing the right thing? Are we asking the right questions? Are we making the right inquiries? Have we applied the correct methodology? Do you have some optimism that this is going to produce good results for Ukraine?
If I was of a different opinion, I would not participate in the competition. I'm convinced that the selection commission is an example to follow, in the, well, with due account of the events that we are currently having in Ukraine. Because I'm sure that if you had an opportunity like that, you would communicate with all of us face to face, because this would allow you to see the candidate better. But in the conditions we are living, I think that this is the best approach. I'm not trying to pay a compliment to you, but I just think that you work on an exemplary basis.
Well, I think most of us will accept the compliment, so I appreciate that. But let me ask you for one final piece of advice for this commission. And I say this respectfully. I'm not saying it flippantly. I say it respectfully. When we get together to talk about the 64 people that we've interviewed here, what should we not forget to do? What must we do in order to make sure that it's the best and the fairest and the most effective process possible? What should we discuss among ourselves or not discuss among ourselves? What questions should we address, and how should we try to resolve our differences?
I think that the Commission is already doing this. Sometimes you have very simple questions, but you kind of insert into those questions rather complex issues related to the theory of law. For example, if you ask about burden of proof, and you do it, so to say, by the way, but in fact, these simple questions contain some tricky elements. So I think that you're already doing this, and I don't think that you need my piece of recommendations. You're working very effectively.
Okay, well, let me say I'm sorry for catching you cold on so many of these things. These are hard issues, and you know they're hard issues, and a lot of the questions that you're hearing involve hard issues, but thank you for your insight and your input. My colleague, Judge Zarzeczny.
Professor Sabodash, I was curious to know and perhaps understand, you were very candid in advising us that you had been an applicant for the Economic Court of Cassation at the Supreme Court of Ukraine. And you were candid enough to tell us that you received on the examination what I would regard as a good score. You were in 27th position. But then you were, in effect, disqualified for having signed the practical task portion of the examination. Now, you as a professor must conduct many examinations of students that are anonymous testing, and you of all people should understand the importance of anonymity to an impartial and independent evaluation of an examination result. And yet you signed this practical task, and that seems incredible to me. Why did you do that?
Believe me, I think I'm the person who is as upset as you are, because it was a 5-hour-long test. We had to write a court judgment in corporate law. It was something about non-payment of dividends. I already completed writing the assignment. I put aside my pen, so let me tell you how it happened. And somebody is sitting behind me asking me what's the correct way to write surname. So I told him that he needed to check in his passport, and for some reason, because he was asking me about first name and surname, I decided to sign my paper. It was my mistake. So you are rightfully mentioning that, and I was disqualified for that very reason. I received 0 points, and that is why I was disqualified. It was a mechanical mistake. I don't know why I did it. But that's what happened. It's my mistake. I acknowledge that it was my mistake.
Well, it's an unfortunate mistake. I wanted to understand that you didn't do this deliberately to sabotage your position. Let me move on to some...
No. I didn't do that on purpose, for sure. Because it was a question that I was really knowledgeable about. And it was something that was discussed during the plenary session of the High Commercial Court, and our department was even providing an opinion with regards to that case. So we were discussing that very case. But that's what happened, and believe me, I'm really, really sorry about making this unfortunate mistake.
Well, I think more to the point, though, in terms of your character, you were good enough to point this out to the Commission, and I think that speaks well. Let me move on to some more, if you like, general discussion about the work of the High Qualification Commission of Judges. You said an interesting thing, I thought, in your introductory remarks. You made the point that, contrary to what might be popular opinion, you would not encourage the Commission, if you were a member of it, to rush into filling vacancies, essentially, I think, suggesting that that would compromise quality for quantity. Do you not think, though, that both can be achieved by some innovative approaches that might be suggested for the HQCJ? For example, there is a publication that suggests that the HQCJ could cope with this extraordinary challenge that it faces by contracting out some of the work that would normally, in normal circumstances, be done by the HQCJ members. For example, psychological testing is already contracted out, and the test used is the MMP test, as I understand it, which is internationally recognized, and There would also be the opportunity to contract out the preparation and scoring of the examinations, whatever they are determined to be, by and to the National School of Judges, for example, or perhaps a volunteer group of judges who could assist not only in preparing the exam, but scoring the exam. That might be particularly applicable to the practical tasks. So, would you agree that there are other innovations that could be considered by the HQCJ to achieve both quality appointments and quantity appointments? Your comments, please.
Thank you. So, your question consists of two questions. Number one, it's about funding. So if we have money, then of course some tasks must be contracted because we are not specialists. The HQCJ is not specialist in psychological tests. But as far as examination tests are concerned, as far as I know, they are already developed by the National School of Judges, and nobody else is being involved in that. So it's already done by the National School of Judges. If we are talking about speeding up, then I would talk about change of approaches in several aspects. The documents can be submitted online. It's quite strange that in the year 2022, 2023, we need to copy documents. And for example, when applying for this selection, we had to interact with some registries. And I also think that even the testing can be done online. So at the moment, it's impossible to do without amendments to the legislation. But leading universities do that. They have remote testing, so the applicant must install some software which will be watching what they're doing. The camera will be watching the movement of their eyes, whether they are using any additional tools, so it will be impossible to cheat. And I believe that we can implement remote testing, and this will speed up the work of HQCJ, and we will not have to involve any contractors. The assessment will be done on the existing platform using the questions that are already prepared by the contractors, and HQCJ will only score the tests, will only check the tests. It's not bad to use contractors to have more tests developed, but still the Commission should do its job, and it's the responsibility of HQCJ to have this final list of questions. I don't think we need to contract this work to somebody else. Why do we need the Commission then? But I believe that we need to introduce some innovative methods in other areas of work. So again, I'm talking about remote testing, online submission of documents, etc.
All right. So I think from what I understand of your answer, you are prepared to collaborate with your colleagues on the Commission, if you should be appointed a member, to attempt to identify some efficiencies that can be achieved so that the work of Commission can be speeded up, so to speak, and fill both expectations, one quality and the other one the need to get on with filling these vacancies in the interests of access to justice. Let me talk about one other area that I'd be interested in your observations about, and that is the role that diversity should play in the selection process of the HQCJ. And I'm speaking about things like geographic diversity, gender, age, experience, experience in the law, whether it be as a prosecutor, a lawyer specializing in civil law, et cetera, et cetera. So how would you deal with providing the kind of diversity of judges appointed that would meet society's expectations, coming as the citizens of Ukraine do, from all different regions, different backgrounds, and perhaps different cultures and traditions?
It should be mentioned here that in Ukraine, and it was already mentioned, that there are no requirements about this diversity, and I understand why you're asking this question, because if I go back to those requirements for the selection in the UK, it is prescribed in those requirements professional competence, then they have good character, and the third requirement is having this diversity that you're asking me about, and it's one of their requirements. It's explicitly mentioned. With us, we don't have this kind of requirement. But if we look at the statistics about the number of judges, about the age of judges, I think that unofficially the Commission tries to follow this diversity. So we have 53% of female judges in trial courts and appellate courts. And if we talk about the Supreme Court, we have some 40% of women there. So less women than men. But I think we need to establish some criteria for us in order to ensure this diversity, but we cannot put diversity above professional competence. So theoretically speaking, if professional competence is on the same level, then we can talk about diversity, but we don't have this kind of formal requirement. If I were to answer your question and I spoke as an individual, then I would tell you, yes, we need to have the diversity, but as a member of the Commission, and the Commission itself will not be able to justify an appointment of a judge because they need to have diversity. But as practice shows us, they are actually doing that behind the scenes without any explicit criteria. And we have the statistics for that. We can see how many female and male judges we have. So maybe unofficially they are applying this criteria, and we are having some kind of balance. Because we do need to have plurality of opinions, and it can be achieved only if we have diverse people. Because if we have only men who are above the age of 40, we will not be able to achieve plurality of opinions. And the same applies to the same age group of women, let's say women above 40. So that's in the interest of justice in general, to have diversity.
Thank you for your answer. There is a vigorous debate that we are aware of with respect to the approach that the High Qualification Commission for Judges in Ukraine should take. There is one constituency that suggests that the process of selecting judges should be virtually mechanized, that everything should be scored, everything has to be fully explained and reasoned, etc., and that there's very little, if any, room for judgment, subjective judgment. On the other hand, there is a constituency that says that that's why we have certain composition of the High Qualification Commission of judges, because each individual member brings their own experience, their knowledge, and their good sense and judgment to the process of selecting judges, and therefore the interviews should be a very important component, should be properly conducted, and that there is a need for decision-making other than just simply scientific approach. What's your comment about that?
I think that an interview must become an integral component in the selection procedure. It's not included in the selection at the moment. I don't think that the formal approach will give us a comprehensive idea about the candidate. Only the interview or the interview as an additional tool will help us get an idea about who is sitting in front of us. And I will not be repeating my ideas, but the interview will help us understand whether the person is knowledgeable, whether they have critical thinking, whether they can listen to others. Maybe some of these things can be revealed during testing, but the majority of this kind of information can be collected during interview. And the thing is that the interviews are not foreseen by the law, so we have this gap in the law. So I think we need maybe to wait and amend the legislation and have the interviews included into the legislation. I don't think that we can use some mechanized tools only.
All right, thank you. I'm going to turn your questioning over now to my colleague, Ivan.
Thank you.
Welcome, Roman. Good afternoon. When I was graduating from the university, that was in 2002, I graduated from the Kyiv Institute of International Relations, not the Taras Shevchenko National University. But unfortunately, I don't remember any of my fellow students dreaming of becoming a judge. The majority wanted to become diplomats, others wanted to work at international law firms, or maybe have a position in one of the top 20 law firms. And I assumed that the situation was similar to your university. You may know this better because you talk to your students on a daily basis. On the other hand, we want for the best people to become judges. But it's hard to achieve for various reasons. How would you see an advocacy campaign? Because the HQCJ would have to have this kind of campaign in order to find the 2,500 people to fill in the vacancy. So how do we find these people? How do we convince them? And how do we find the best young specialists who would like to join the judiciary? As far as young specialists who would become judges, I think that we have the age limit. There are some limitations as far as age and experience are concerned. But the UN tells us that a person is considered young if they are aged under 42, so that's fine. I think that when we are selecting the best of the best, we are talking about people who have the skills of critical thinking, who have the knowledge, but we also need to consider having an ambition. So we need to think both about ambition and the actual possibility to become a judge. So if people see that the procedures of selection are transparent, they are not biased, then a person would see that it's possible to become a judge. It's the same as with entering a university. So when we say that we have the independent external assessment and you will be enrolled based on the results of those testing, then everybody understands the procedure. So currently, this profession is not that prestigious, but it's still prestigious. And I think that what we can do is we can say that the profession of a judge promotes the change of attitude, not just towards the judiciary, but the attitudes towards the country in general. We are talking about a utopia, having all best of the best among judges, but still we are talking about the image of the country, so maybe we could talk about ambitions, because administering justice is something that cannot be done by everybody, and it should be an ambitious person, somebody who is quite ambitious. Yes, I agree with you. During our interview, we have not yet discussed something that is quite important, and that is integrity. Everybody is talking about it. How do we assess integrity? And I'm interested in your opinion in the context of young specialists. Very often our candidates tell us that we need to analyze declarations, that we need to look at previous background and work experience. But if we are talking about young specialists, people who just recently joined the profession, who just recently graduated from their law schools, so they don't have this previous background that we can analyze. They don't have that many achievements as yet. They are just starting out on their professional path. So how do we assess their integrity? So let me give you a more general answer. If we are assessing integrity, what is integrity, first of all? Integrity is assessment of your current and previous behavior to see whether it meets some standards. So we can break it down into financial and property aspect. And I think it can also be applicable to young specialists. The next component is professional ethics and activities. And the third component, some disciplinary actions imposed against the person, violations of traffic rules, for instance. I mean, some driving under the influence violations, jumping the red lights, etc., etc., and also the behavior of the person in their private life. So we can see, for instance, how a person behaves on social media if they have profiles. We can see what their lifestyle is. We can see whether they have traveled to Russia. If we are talking about young people, we can also check whether they've crossed the border of the country during the war. And I think that the armed forces of Ukraine should not be the place of punishment. If we are talking about property aspects, it's not just about the assets, but it's about complying with the tax legislation and regulations. And we have to be flexible here because our tax legislation may be ambiguous, it may be complicated, but we can consider the facts of a person paying off their debts. We can look at bankruptcy, their financial behavior. So all these things should be assessed. When we are talking about professional ethics, it's not just the ethics of a lawyer, because even our students at the university must follow the code of ethics. So we are trying to assess a person's entire life, but if we look at the practice of other countries, similar commissions assess specific periods in a person's life, let's say some 11 years, especially if we are looking at some disciplinary action. So we are giving people the ability to be rehabilitated, because that is why we may be losing the purpose of atonement. So there are different aspects that should be taken into account. It's not just the analysis of tax declarations, but it's one of the main sources of information still. The new HQCJ will be faced with a huge workload. Many processes will be launched at the same time. But if we are talking not so much about the process, but about the result, let's assume that you've become a new member of the HQCJ. What will you consider to be a sign of success? That the HQCJ has accomplished something, it has achieved its goal. When will you realize that the goal has been achieved? What's going to be the main factor? I wrote about that in my motivational letter, and I think I still share this opinion. So the work of HQCJ and the revival of trust in the judiciary lies in the work of HQCJ itself, but it's not just the responsibility of HQCJ, it's also the responsibility of HCJ and the judges themselves. It's a popular opinion that the judges must maintain the authority of justice. So the HQCJ must work in such a way that people have no doubts about the procedures of HQCJ, that people have no doubts about the standards, so that no questions are asked about the activities of HQCJ, and we will see that in the surveys of public opinion. So it's a good tool to be used. So when we see that the society has no serious reservations or concerns with regards to our selection, then the other authorities will have to do their job to enhance the level of trust. But what I would consider to be a good result is that the society accepts the results of our work as good and diligent, and when the society has no reservations or concerns. So if HQCJ tries to complete some procedures not allowing the civil society to express their opinion, I'm talking about the previous HQCJ, when we didn't have broadcasting at all times, when the opinion of civil society was not taken into account. So what the previous commission was doing was not working for the positive result, but they rather achieved negative results at times. So we must ensure that the new HQCJ achieves this positive perception of the selection. And for me, that would be a sign of a positive result. And also, we must have adopted standards. Thank you. Thank you. Thank you. I'm now passing the floor to Robert.
Yes, there are quite some subjects left, unfortunately. You said quite a lot about testing. But do you have any knowledge of testing? Because you're a civil lawyer and not a psychologist. How did you get your knowledge about testing? I understand you have looked at the website of the selection of UK lawyers, but do you have any other knowledge about that?
It's like in the court. You have special knowledge that is normally outsourced, and that's something that the previous commission did with testing of moral and psychological qualities. And we, as members of the commission, cannot create tests. We can outsource these tasks, and we can ask our own questions.
That, but that means that you say that you do not have specific knowledge about testing. Is that correct?
Yes. if we are talking about testing of moral and ethical qualities, because this is special knowledge that psychologists have. And I'm saying that these tests should be outsourced and developed by specialists. And we are specialists in the field of law.
Okay, thank you. Maybe if you consider testing, have a look at the Netherlands. Much more advanced than the UK, I can tell you. The testing exists for 35 years. Also moral testing, also testing of analysis. Any judge has to pass that. I'm very much in favor of that, to the contrary of my colleague. Do you have any experience in selecting people?
Selecting people. As a teacher, I was previously involved in entrance tests, and as a lawyer, my clients always ask me to help them with finding in-house lawyers, to select new lawyers. So we are involved during the interviews. When we are trying to find a lawyer for our clients. So
But
we
that
are
means
asked
that, sorry,
to show
but
up to such interviews.
it means that sometimes a client wants you to be present, but you're not someone who is actively present in selecting, because your students are your students, you don't select them. Of course, you take examinations, it's a form of selection, but you don't offer them a job. And sometimes a client wants your help, and you want them to sit in an interview where they do the selection. Is that correct? Yeah. So,
Yes, of course, I'm not offering a job to my students that goes against the ethics. I cannot use my position to select students for my own purposes. Yes, but you understood it correctly. Sometimes clients invite me as an external observer to assess the knowledge of people who they are hiring as their in-house lawyer.
yeah. Then the question I always ask you, you are, let's say, a professor and a lawyer. Did you ever experience corruption in your either academic career and or your career as a lawyer? Directly, did you ever see anything of corruption? Did you see anything of corruption within the judiciary? Did you see it within the academic world? I'm told that also in the academic world there's quite a lot of corruption, and that sometimes it's possible to get a higher grade if you pay for it. As a lawyer, I would say that you're part of the system, and I said many times before, from my knowledge, it always takes two to tango. So someone takes the bribe and someone pays the bribe. So what is your knowledge about that?
Well, I can just tell that the person who will address me with such a sort of proposal will, well, this will be the last thing he will do in our relationship. Because I'm lucky enough.
The question was, did you ever have experience in it? The question was, did you have experience? Do you have any personal experience of corruption? Did you ever see it in the academic world, in your legal community, when you went to court, when you were with clients, or doesn't it exist?
Okay, so let me rephrase it and repeat. If I were a witness of this, this would also be the end of my relationship. I have, with all my conduct, demonstrated that nobody could even show corruption in my presence, and I hope that this will remain so forever. As far as experience of knowing about corruption, well, yes, I know it exists, but I have not faced it.
And also not in your academic world? Has there never been a student coming to you, say, give me a higher grade, I will pay you €1,000 or something?
No, that would be the greatest blunder of that student if he did it.
Well, I'm told that sometimes students do it and it works. Or is that a story from that doesn't exist?
Well, we are talking now. Well, let me explain. Corruption can exist in case it is tolerated in a certain environment, in a certain society, or even in a certain team. It so happened that our department of the university is normally the department of successful people who are either businessmen or are successful practicing lawyers or scientific academicians and scientists. And the attitude the corruption in our department is very negative. We do not tolerate it. That's why I think students are not addressing us with such offers.
Okay.
And at least they have not addressed me, and I have never seen it happen.
You know what I find so strange? I say time after time again, I read reports from USAID and all kinds of organizations. They say it exists. I have interviews here with academics and judges. And I see that some of the people, they drive the biggest Mercedeses and BMWs, and they live in the most beautiful big houses. And they have, when asked where the money comes from, they always get it from their mother or father-in-law. And when we then ask from people, academics and others, to say, well, does it exist? And no one has ever experienced it. And you're an academic. Explain to me how it is possible that everyone in literature says it exists, and if I ask 20 people who live in this world, the academic world, the legal world, no one has ever seen it. And if it doesn't exist, why are we here as a commission?
Well, I don't mean that corruption does not exist. First of all, you know, you have diversity of applicants. The applicants, the candidates are rather specific, but when we speak about reasonable doubt and about the examples you have shown, you know, nobody is going to ever say, to ever confess that he or she is corrupt. That's why we apply these methods of assessment of the reputation, which are indirect methods, like income, correlation between the costs and the income, the sources of origin of the money, whether there are sufficient grounds to think.
I understand that. Yeah, yes, but are you saying to me that if I ask you, did you ever experience corruption in your work, and your answer is no, that this answer is not necessarily correct?
Well, actually, every answer may be not exactly correct. Well, at least I hope that my reputation is really what I tell. And I have never had cases when somebody addressed me with this, but any answer can be wrong.
Okay.
And you can actually check my words the way you do this for the words of other candidates. You can actually check it by my way of living, by my income, and so on and so forth.
Well, that's where I wanted to go to. That's did you look at your file as a preparation for this interview? Yeah.
Yes, yes, of
Have you
course.
seen the civil society information in your file? And we have asked you quite a number of questions. Sorry?
Yes, I saw that there was something on the declaration, and some of the remarks were related to the fact that I declared property as joint property, and in the last declaration I indicated that this was my wife's property. But that was related to the fact that the explanations of the NACP were different in different periods of time, and I gave references to those explanations of the NACP. The NACP said that if you indicate that this is joint property, if you have joint property, you have to indicate it as joint property. But the latest explanations claim that regardless of what type of property it is, under the family code, you have to indicate only the title owner. So I think that the changes have been introduced because it's easier to check something by the title owner than to check whether this property was acquired within the marriage or not. But in the note to this property, I also indicated that I'm using this property because it is in joint property. So I still managed to somehow reflect the true information about the fact that this is joint property. But there were no other remarks. There was also a remark about where from my wife has got the apartment, and I got the certificate of inheritance from her parents. So the certificate should be there in your materials.
Yeah, I've seen that, of course, and I've seen your answers. I've seen the questions. For a foreigner, it's very difficult to judge what is right or what is wrong, because the rules are complex, I'm told every time. But what I wanted to know from you, that after, let's say, answering to our question, did you or did you not fill in your declarations correctly? Because that is not clear to me from your answers that are in the file.
You know, the question was that there was the explanation of the National Agency for Corruption Prevention on how you have to declare the apartment which is joint property. If it was acquired during marriage, according to our law, this is joint property of the wife and the husband. And fulfilling the requirements of the family code, I registered it as an apartment acquired while I wasn't married. And that's why it's joint property. But since, well, and I checked the database of their NACP, and their explanation changed. So they now indicate that you just have to indicate the title owner, and my wife is indicated as the title owner, though this is actually our joint properties. That's why I have to ignore the requirements of the family law according to the rules of the NACP and indicate my wife as the owner. So that just was following the clarifications of the NACP. But this is the same apartment. I still think that it is joint property of me and my wife, but the title owner, the person registered in the register, is my wife. That's the only thing I would like to say.
But that doesn't answer my simple question. Was it correct, the declarations, or was it incorrect?
I don't think that this was incorrect, that this was a mistake. This was just fulfillment of the requirements of NACP. I think that the requirements are wrong, but I performed them. I complied with those requirements, and then that's why I have to explain to you now why I did it.
Okay, thank you. I'm just looking around whether someone else has a question. I'm sure they don't. We're coming to the end of our interview. You see, we still needed 81 minutes of time, which is quite long. I'm sorry for that. But to end it up, you have 2 minutes to say what you would like to say, something you have forgotten or would like to explain or to add. Please go ahead.
I would just like to respond to Robert's question concerning corruption in the society. I don't object that there is corruption in the society. Otherwise, there would be no decision about relaunching of the Qualification Commission, there would be no Selection Commission, and there wouldn't be no other problems in the society. I'm sure that this problem really exists, and it's quite significant for our society. But I can judge only by myself that I have got no personal experience of this. I was not involved in any actions, and I was not present. I was not a witness. But I do recognize that this problem exists. And all the more, I consider this problem to be one of the major problems that is difficult to overcome. That's why we should take pains to overcome this negative phenomena, in particular using such tools as integrity vetting of the judicial candidates. This is the main objective of this process. As to all the other things, I'm really grateful to the commissioners for the questions asked, because I think that the discussion has been rather interesting, at least for me. And anyway, this is experience, be it positive or negative. It's always experience, and this matters. Thank you.
Thank you. We close the interview, and thank you for your participation and your time.